If your employment contract contains a non-compete clause, you may be wondering whether or not this is enforceable. I'm Mike from Cashion Legal, and in this video, I'm going to cover the topic of non-compete clauses in Alberta employment contracts. At the end of this video, you'll have a better understanding about whether the non-compete clause in your contract is enforceable or not, and how you can plan for your future employment if you are subject to a non-compete clause. It's worth pointing out that the information shared in this video is general in nature and may not answer the question for your specific circumstances. Whether or not any particular non-compete clause is enforceable or not is a fact-specific analysis that depends on the wording of the clause itself and the circumstances of your employment. This video will provide high-level information about the enforceability of non-compete clauses, but if you're looking to compete with your current or former employer, I strongly encourage you to seek legal advice. You can do this by clicking the link to our website in the description of this video and booking a consultation with our office. Let's start with answering a very basic question. Specifically, what is a non-compete clause? In the employment context, a non-compete clause is any clause in your employment contract that prohibits you from working for a competitor either during or after your employment. Non-compete clauses generally include language which restricts your ability to work for competitors or start a competing business. The intention behind a properly drafted non-compete clause is to protect an employer's competitive advantage in the marketplace by preventing employees from misusing confidential information for the benefit of a competing business. This purpose is very important to understanding whether or not a non-compete clause is enforceable, because in order to be enforceable, a non-compete clause must protect a legitimate proprietary interest. That object of protection, being the legitimate proprietary interest, is understood to include trade secrets, confidential information, or even in some circumstances, particular client relationships. In order to be enforceable, a non-compete clause must only be directed towards protecting that legitimate proprietary interest. Otherwise, it will not be upheld by the courts. So even though that's what non-compete clauses are supposed to do, in many circumstances they go too far and impose illegal restrictions. If a non-compete clause imposes illegal restrictions, it will be found to be unenforceable. Before I dive fully into this topic of enforceability, it's important to understand the broader context within which non-compete clauses operate. Non-compete clauses fall within a broader category of contractual terms called restrictive covenants, and these are obligations that employers impose on their employees to restrict their activities. Non-compete clauses are generally seen as the broadest form of restrictive covenant because they contain blanket prohibitions on what the employee can and cannot do during and after their employment. In addition to non-compete clauses, there are more narrow and focused forms of restrictions that employers can impose on their employees in order to protect their interests. For example, an employer can impose a non-solicitation clause on an employee. Additionally, employers can simply impose confidentiality obligations on employees, which don't actually restrict competition or solicitation, but seek to protect the employer's confidential information. In order to understand whether your non-compete clause is enforceable or not, it's important to be aware that employers have these other options available to them. With that greater context established, let's move on to the main topic of this video, which is when is a non-compete clause enforceable and when is it not? While there is no one-size-fits-all answer to this analysis, there is a broad set of principles that we can review in order to help you understand whether or not your non-compete clause is enforceable. The first thing to know about the analysis is that courts start from a basic presumption that non-compete clauses are not enforceable, and that in order to enforce a non-compete clause, an employer must satisfy certain criteria. More specifically, an employer must prove that the non-compete clause is fair, reasonable, and necessary in the circumstances. In order to conduct this analysis, there's an established list of factors that the court will look at in order to assess the enforceability of a non-compete clause. This list of factors includes 1. Whether the non-compete clause is necessary to protect the legitimate proprietary interest, 2. Whether the non-compete clause is clear and unambiguous, and 3. Whether the non-compete clause is reasonable in its scope. Let me unpack each one of these factors. With respect to the necessity factor, in order to establish the enforceability of the non-compete clause, the employer must show that the non-compete is necessary to protect the legitimate proprietary interest. This brings us back to the broader context within which non-competes operate, specifically the other forms of restrictions that employers can impose on their employees. If an employee can prove that the employer's legitimate proprietary interest would be sufficiently protected by a less onerous restriction like a non-solicitation clause or a confidentiality agreement, then this will mean that the employer cannot enforce the non-compete clause. Put another way, if you establish that less drastic measures would achieve the employer's goal, you've demonstrated that the non-compete clause is not necessary. In these circumstances, the court will not uphold the non-compete clause. The second factor I mentioned was that the non-compete clause must be clear and unambiguous. A court will not uphold a non-compete clause if it is ambiguous as to what the employee can and cannot do. The primary reason why a non-compete clause needs to be clear and unambiguous to be enforceable is a matter of fairness towards the employee. If an employee cannot determine what they can and cannot do simply by reading the clause, this would be unfair to impose these restrictions on them. This means that if the restricted activities cannot be readily determined through a simple review of the clause itself, the court is unlikely to uphold the non-compete clause. The third factor that I mentioned was reasonableness. Any non-compete clause must be reasonable in its scope of restricted activities. This means that an employer cannot restrict you from engaging in activities in which the employer does not actually engage in. Similarly, the clause must be reasonable in its duration and in its geographic scope. Any non-compete clause cannot go on indefinitely, and it must be limited by some amount of time. What amount of time might be reasonable for a non-compete clause is dependent on the circumstances. Similarly, a non-compete clause must be reasonable in its geographic restrictions. Your employer cannot prohibit you from working in a city in which they do not conduct business. So if your employer exclusively conducts business in Edmonton, Alberta, they cannot have a non-compete clause that prohibits you from working in Calgary, Alberta. So now that we've looked at some of the factors the courts will look at in assessing the enforceability of a non-compete clause, this begs the question, when will a court uphold a non-compete clause? As you've probably guessed, the bar for enforcing a non-compete clause is very high. The reality is that it's very difficult for your employer to convince a court to uphold your non-compete clause, particularly where there are less intrusive options like a non-solicitation clause or a confidentiality clause available to your employer. Having said that, while Canadian courts are generally hesitant to uphold these types of clauses, there are circumstances where they might be appropriate. For example, a non-compete clause is more likely to be enforceable in the case of a senior executive. By virtue of their position, senior executives possess a significant amount of confidential information, so there are circumstances where a non-competition might be necessary to prevent them from using that confidential information for the benefit of a competitor. For this small group of employees, it might be virtually impossible for them to assume a similar position with a competing business without them making use of that confidential information. Additionally, there may be certain sales roles where a court will determine that a non-competition clause is enforceable. While I can't cover every circumstance in this video, the point is that even though it's rare, there are circumstances where courts will uphold non-compete clauses. So you may be wondering, if it's so difficult for my employer to enforce the non-compete clause, do I even need to be worried about it? The reality is that even if your non-compete clause is not enforceable, it can still have negative impacts on you moving forward. I'm going to briefly review some of the circumstances where a non-compete clause can impact your future employment even if it's not enforceable. Firstly, sometimes a prospective employer will ask you whether or not you are subject to a non-compete clause. Because you need to be honest with your employer, if you are asked this question, you must disclose the existence of your non-compete clause. And this may give the prospective employer second thoughts about hiring you. Secondly, even if a non-compete clause is not enforceable, this does not mean that your former employer will not attempt to enforce the non-compete clause. In this scenario, you might leave your employer, join a competitor or start a competing business, and then find yourself subjected to aggressive legal action by your former employer. This legal action can include attempts to restrain your competitive activities or even seeking damages for losses that you may have caused through your allegedly illegal competition. So if the non-compete clause is unenforceable, what's the risk associated with this? Even if you're ultimately successful in defending any legal action advanced by your former employer, in this situation you would still spend a significant amount of time, money, and energy defending this lawsuit. Furthermore, you would not necessarily recover all of the legal fees that you spent in defending the action. This is something that you obviously want to avoid. So, what should you do if you're subject to a non-compete clause? Again, the information that I'm sharing in this video is general in nature, and you should consult with a lawyer before developing a strategy for your situation. However, here are some general tips that we share with our clients when dealing with this situation. First and foremost, if you do intend to compete with your former employer, you must always respect your confidentiality obligations. Even if you don't have a confidentiality clause in your employment contract, you still have a general duty at common law to protect your employer's confidential information. This means that if you had access to your employer's confidential information during your employment, you cannot misuse that confidential information to your benefit after you leave. For this reason, we always discourage people from engaging in data dumps, which is when you take significant amounts of confidential information in connection with your departure. This type of conduct carries significant consequences and is likely to result in legal action from your former employer. Doing this could be very costly for you in the future. Secondly, we generally encourage people to be honest and forthright in these circumstances. While you don't need to proactively disclose to your former employer that you're in competition, if you do receive an allegation that you're in breach of your obligations owed to that company, sometimes candor can go a long way. Employers often assume the worst when they have limited information about what you're doing. They might believe that you are misusing confidential information or that you're attempting to solicit key clients. Clear, honest communication to your former employer can often diffuse the situation, and it gets ahead of any argument that you are being dishonest about your conduct. This honesty can prove very helpful in legal proceedings if your former employer does decide to escalate things. Courts will generally look favorably on people who are transparent and reasonable in their conduct. The third thing that we encourage people to do is negotiate in these circumstances. If your employer is attempting to enforce a non-compete clause, it doesn't have to be an all or nothing fight. It may be that your former employer is simply looking to protect a key client or a specific piece of information. In this situation, there might be a less onerous restriction that you could agree to that would stop any legal action from your former employer. For that reason, it's always worthwhile to consider these compromises before escalating the legal action between you and your former employer. Negotiations in this situation can reduce legal costs, delay, and stress, so it's a valuable option to consider at this stage of the proceedings. The bottom line is that there is no one-size-fits-all answer to the question about whether or not a non-compete clause is enforceable. Having said that, it is fair to say that employers face a relatively high bar when enforcing non-compete clauses. The employer has to prove that the non-compete clause is necessary in the circumstances, clear and unambiguous, and reasonable in its scope. However, even if your non-compete clause is unenforceable, its existence alone could carry negative consequences for you. If you are subject to a non-compete clause and looking to compete with your former employer, we can assist you with this. We provide employees who are subject to non-compete clauses with clarity about their circumstances, strategy for navigating the path forward, and peace of mind through sound advice and strong representation. If you're looking to connect with the team at Cashion Legal, you can click the link to our website in the description of this video and book a consultation with our office today.